качестве руководителя кафедры ЮНЕСКО по авторскому праву, смежным культурным и информационным правам Высшей школы экономики я имею честь и удовольствие объявить о начале нашего сегодняшнего научного коллоквиума. Он посвящен очень важной теме, перспективам развития права интеллектуальной собственности в 21 веке. И для того, чтобы поднять эту тему, в качестве ключевого докладчика мы попросили выступить профессора Мэггса. Профессор Питер Мэггс очень известен во всем мире, и прежде всего, конечно, он известен в Соединенных Штатах Америки и в России, а также в целом ряде стран на постсоветском пространстве. Потому что профессор Мэггс является крупнейшим специалистом по постсоветскому законодательству и прежде всего по законодательству в области интеллектуальной собственности. Я счастлив, что Питер Мэггс согласился сделать свой доклад на нашем коллоквиуме. И у нас будет у всех возможность не только его выслушать, но задать ему вопросы, вступить с ним в полемику. И вот ближайшие 3 часа обещают нам настоящее пиршество, интеллектуальное пиршество в области интеллектуальной собственности. И сейчас я хотел бы предоставить слово декану факультета права Высшей школы экономики, профессору Вадиму Александровичу Виноградову. Вадим Александрович, вы с нами?
Да, Михаил Александрович, добрый день, уважаемые коллеги. Рад всех приветствовать, всех участников. Тема действительно, эта инициатива кафедры ЮНЕСКО очень важна для факультета, потому что интеллектуальная собственность – это то направление, которое, безусловно, одно из ключевых для факультета права Высшей школы экономики, причем как для таких научных исследований, так и для того, чтобы иметь возможность изучить всю практику и ориентировать студентов на это очень важное направление, особенно тогда, когда у нас развивается цифровизация во всем мире, и в этом смысле тоже интеллектуальная собственность и занимает свое особое место. Для нас важно также не только понимать, как защищать интеллектуальную собственность, но и важны вопросы, условно, защиты от злоупотребления интеллектуальной собственности. Коллеги, наверное, знают, что сейчас идут судебные процессы, которые связаны с так называемыми патентными троллями. И, вот, например, компания Samsung в России как раз подверглась такой нападению, если так можно сказать, этих патентных троллей, которые используют лакуны российского законодательства для того, чтобы злоупотреблять правами по интеллектуальной собственности. Интерес к этому действительно велик. Я знаю, что зарегистрировались поучаствовать в этом мероприятии больше 500 человек, и, конечно, у нас нет возможности подключить всех, но у нас открыта трансляция, и еще раз я рад всех поприветствовать и пожелать плодотворной работы, интересных дискуссий, вопросов, и действительно это очень большое для нас, факультета права, мероприятие, и я еще раз хотел бы поблагодарить кафедру ЮНЕСКО за эту прекрасную инициативу и, конечно же, профессора Мэггса. Спасибо.
Спасибо, Вадим Александрович. Я хотел бы сказать, что сегодня действительно у нас зарегистрировалось более 500 участников. Кто-то уже успел подключиться, кто-то еще не успел. Но мы открыты для нашей работы со всеми. И я бы хотел отметить еще то, что вот я не зря сказал о том, что профессора Мэггса очень хорошо знают специалисты в области интеллектуальной собственности на постсоветском пространстве. Поэтому неудивительно, что среди сегодняшних участников есть наши коллеги из Узбекистана, из Украины, из Белоруссии, из Армении, из Грузии и из других бывших советских республик. Они все знают прекрасно профессора Мэггса. высоко ценит его квалификацию и его помощь, которую он оказывал этим странам, когда они создавали свое национальное законодательство в области интеллектуальной собственности. Но не буду отвлекаться от главного нашего докладчика. И хотел бы сейчас предоставить слово руководителю Федеральной службы по интеллектуальной собственности, профессору Григорию Ивлееву. Григорий Петрович, пожалуйста.
Уважаемый господин Федотов, уважаемый господин Мэггс, уважаемый господин Виноградов, от имени Федеральной службы по интеллектуальной собственности приветствую такую инициативу и такую хорошую работу по организации коллоквиума, темой которого является будущее интеллектуальной собственности. Все-таки понимание того, как мы развиваемся, куда мы идем, это, наверное, главное, что мы всегда ищем в таких форматах, как коллоквиум, как выступление известного профессора, как критика, которая может быть звучать на таких научных мероприятиях. Я хотел бы подчеркнуть, что в 21 веке, в это время, в 22 по 26 год в качестве основного вектора дальнейшего развития ВАИС в своем среднесрочном стратегическом плане приняла тему создания экосистемы интеллектуальной собственности. И это для нас будет ориентиром и источником вдохновения. Мы, как ведомство, полностью разделяем эту инициативу, и мы видим, что целью создания экосистемы будет трансформация интеллектуальной собственности в высоколиквидный актив. Мы, чтобы достичь эту цель, поставили следующие задачи. Преодоление регуляторного и технологического разрыва между созданием и коммерциализацией результатов интеллектуальной деятельности, развитие мотивационных стимулов по созданию и внедрению результатов интеллектуальной деятельности, реализация мер по стимулированию оборота прав на результаты интеллектуальной деятельности, экономическое стимулирование оборота прав на результаты деятельности. Все это должно реализоваться в комплексном подходе к цифровой трансформации интеллектуальной собственности, и мы видим, что уже сейчас мы начинаем действовать в стандарте 3D. Комитет по стандартам ВАИС в ноябре утвердил наше предложение по формированию такого стандарта, и мы видим, что ближайшее будущее из системы интеллектуальной собственности будет формироваться в 3D-форматах. Конечно, очень важны интеграционные моменты, которые сейчас в интеллектуальной собственности развиваются. Для России, например, этот год будет годом завершения присоединения ко всем международно-правовым документам в сфере интеллектуальной собственности, которые принимались. Мы внесли в Госдуму, и там находится сейчас на обсуждении, в декабре будет принят закон о присоединении к Лиссабонской системе регистрации географических указаний. Знаменательность этого события в том, что мы завершаем, Россия завершает внедрение всей своей системы в мировое пространство интеллектуальной собственности. И, конечно же, для нас очень важен интеграционный региональный момент. Мы видим, что на территории Евразии интеграция имеет сложный характер. Мы с 1995 года выдаем единый патент на изобретение, с 2021 года уже выдаем единый патент на промобразец, но нам нужны другие объекты охватить. Кроме всего прочего, под евразийскую интеграцию необходимо общее экспертно-патентное пространство, необходима единая юрисдикция, касающаяся и административного разрешения споров, и судебного разрешения споров. Задачи большие. Спасибо профессору Мэггсу, что он к нам зашел вот с такой высоты. Мы надеемся, что мы услышим необходимую информацию. Кроме меня, от Роспатента участвует мой заместитель Юрий Сергеевич Зубов в этом мероприятии. И мы хотели бы еще в процессе этой работы также рассказать о том, как мы видим какие-то проблемы, или уточнить и спросить профессора, что он может нам на это сказать. Спасибо.
Спасибо, Григорий Петрович. Юрий Сергеевич, здравствуйте, дорогой. Мы вас приветствуем. И
Здравствуйте.
да, всегда будем готовы предоставить вам слово в дискуссии по докладу профессора Мэггса. Уважаемые коллеги, прежде чем передать слово профессору Мэггсу, я хотел бы сказать, что я очень горд тем, что профессор Мэггс уже довольно много лет является ассоциированным членом нашей кафедры ЮНЕСКО. И он опубликовал в нашем кафедральном журнале «Труды по интеллектуальной собственности» довольно много своих статей. И мы всегда отмечали, что его статьи показывают высочайший уровень научного осмысления тех проблем, о которых он пишет. Причем этот уровень, высочайший уровень осмысления характерен и для его статей, например, по тематике товарных знаков или по такой острой сегодня тематике, как правовой режим социальных сетей. Профессор Мэггс – человек с очень широким кругозором и очень высоким уровнем научного осмысления правовой действительности. Профессор Мэггс, слово вам. Take the floor, please.
Thank you very much for that flattering introduction. And I'd like to thank Professor Fedotov, his cafedra, and the university very much for inviting me and very much for all I have gained from past years of cooperation. Today, I'd like to talk about the future of intellectual property in the 21st century. And I'll begin with a quotation from the famous American baseball player, Yogi Berra, who also was known as a popular philosopher for his sayings. He said something not very original, but still very important. It's tough to make predictions, especially about the future. Thus, today, I will be venturing into dangerous territory. Some scholars have attempted to put all of intellectual property into some sort of grand theory. I don't think that is really practical. And I turn back to the 19th century, in which Charles Darwin developed a great theory of evolution in his book, The Origin of Species, explaining it by the survival of the fittest. However, even Darwin saw that no one theory could explain everything, and he added a second theory that in another book, that of sexual selection, involving not the survival of the fittest, but the success in the market for reproduction, explaining the development of bird plumage as a way, for instance, of signaling. Intellectual property, like evolution, should be divided at least into two large groups. The first is that of providing an incentive for creative activity. The United States Constitution explicitly made possible the enactment by the federal government of patent and copyright legislation effective throughout the country, in the words of the Constitution, to promote the progress of science and the useful arts. Translating this from 18th century English to modern American English, this phrase would mean to promote the progress of knowledge and useful technology. Just as evolution has enriched the world through the survival of the fittest, patents have led to highly beneficial inventions and copyrights, and have made the world ever richer in the arts. Trademarks have served quite different functions by signaling quality.
Да нет, это слишком общее, это меня не интересно. Я не буду это дальше слушать.
Facilitating consumer research. Given the very different nature of basic types of intellectual property, It is no surprise that the United States Supreme Court, almost a century and a half ago, decided that the patent and copyright clause of the Constitution did not grant Congress the power to regulate trademarks, but left the way open for Congress to use its power to regulate commerce, to create nationwide trademark protection. James Madison, one of the drafters of the Constitution, and later the fourth president of the United States, in urging the adoption of the Constitution, had argued the states cannot separately make effectual provision for either copyright or patent. The issue of unification of intellectual property law on the level of one country, raised by Madison, has now moved from an issue for a single country's legal system to the issue of intellectual property law at the 19th century, at the international level. The 19th and 20th centuries saw a partial unification of intellectual property law by multilateral treaties and new international institutions. Intellectual property in the 21st century faces serious challenges from rapid advances in science, technology, and widening conflicts between information exporting and information importing countries. I'd like to turn to discussion of various areas of intellectual property in two groups. First, those encouraging creative activity and investment, and second, those encouraging product quality and facilitating consumer research. As I mentioned, some branches of intellectual property law, for instance, patent and copyright, have as their purpose the creation of incentives for creativity through the grant of exclusive rights. However, because the incentives are based on the creation of monopoly rights, which result in decreased production, it is important that there be a proper balance between the benefits of incentives and the negative effects of monopoly. Other branches, such as trademarks and marks of geographic origin, have as a purpose the assurance of quality and the facilitation of consumer search. However, in these branches of intellectual property, it is necessary to maintain a balance between exclusive rights on the one hand and the benefits of competition and free speech on the other. Today, I'd like to discuss the imbalances that have emerged and are emerging in intellectual property law, along with some measures that are being taken or could be taken to deal with them. When the United States patent system was created well over 200 years ago, inventions were simple. Few businesses held more than one or two patents, and expired patents quickly put important technologies into the public domain. Today, the situation is very different in two respects. The emergence of huge patent portfolios and the rapid obsolescence of technology. The most serious problem facing patent law in the 21st century is the continued rapid growth of huge patent portfolios by giant corporate groups. IFI Patent Claim Services publishes a highly useful list of the 250 largest patent portfolios. Here I will pause and send the audience a chat with the address of a draft of my talk. I apologize for the quality of the draft. It's not finished, but I think the footnotes will be very useful because every source I cite in my talk is mentioned in the footnotes, and every footnote is not to some obscure book on a library shelf, but to a site you can easily access on the internet. This list shows that as of early 2021, 51 corporate groups, each owned over 10,000 unexpired patents. Samsung.
Да, Настя?
Здесь есть какой-то алфавит? Ну, тот, который только...
Samsung led the list with over 80,000 unexpired patents. The rapid obsolescence of technology has made largely irrelevant the idea embodied in the United States Constitution that a patent owner should receive a monopoly for a limited time for the disclosure of the invention and its eventual passage into the public domain. The current pace of advance of science and technology means that a large portion of inventions have been overtaken by new inventions at the time the patents expire, so their entry into public domain is of little importance because new patents have made such advances in the art. Meanwhile, patent portfolios are continuing to grow. Apple currently has about 18,000 patents. Of course, in say 17 years, nearly all of these will have expired, but Apple is adding about 2,700 patents a year, so that in 17 years at this pace, it may have accumulated about 46,000 new patents in its portfolio. The ever increasing number of patent applications creates a number of issues. One very simple but important issue is that it makes it more and more difficult for patent offices to be able to have the funds to maintain sufficient staff to keep up with the ever-growing number of new inventions.
Так, сэкономлены средства предпринимателя во взаимодействии.
Such huge patent portfolios create a serious barrier to entry for the kind of small startup company like Apple Computer in its first days in a garage, startup companies that have often led to huge technological advances. Startups will need to spend large amounts of initial capital, paying expensive lawyers to guide them through the patent minefield. Furthermore, they will need money to pay for licenses to patents that block their way. Meanwhile, large established companies with extensive patent portfolios and large legal staffs are much better positioned to overcome these obstacles to innovation. In particular, they can use their patent portfolios as bargaining chips to obtain needed licenses and use their expert legal staff to challenge dubious patents. In this connection, as an aside, I'd like to turn to patent trolls, which were mentioned earlier. One good feature of having very powerful companies holding portfolios of patents such as Google and Samsung and Apple is that they are willing to spend the money necessary to fight patent trolls. But we need to try to find ways to fight patent trolls without smothering startup companies. Several developments in some countries have mitigated negative effects of huge portfolios, but much more needs to be done both at the national and international level. In the United States, because Congress has been very slow to revise intellectual property law, a lot of the changes have been made by the Supreme Court, which has felt free to make very major innovations in patent law. And again, I'll cite a number of Supreme Court cases. All the cases I cite are cited in footnotes to my article to official websites of the Supreme Court or the Library of Congress of the United States. In the 2006 case of eBay versus Merck Exchange, the Supreme Court overturned prior judicial practice in holding that injunctions should not be automatically available for all infringement. Before that, the lower courts routinely granted an injunction for any case of patent infringement. This decision was of great importance for prospective entrants into fields such as the design and manufacture of mobile phones and self-driving vehicles, because of the existence of thousands of patents on the relevant technologies. It also helped deal with patent trolling, because a patent troll could no longer, by some tiny claimed advance, hold up the marketing of a major product. What remains now is to get a proper balance of remedies for patents, and this is still an area of experimentation, and in the United States, an experiment of making new rules by the Supreme Court. The denial of injunctions would be of little use to new entrants if they faced royalties based upon the total value of their entire product. For instance, if the patent holder of a single patent related to mobile phone technology, even if it could not seek an injunction, could seek a royalty as a substantial percentage of the typical $400 cost of a modern mobile phone. However, again, the Supreme Court has adjusted the law. In Samsung Electronics versus Apple, which involved a design patent on the familiar iPhone interface, Apple sought damages and got damages in the lower courts based upon a percentage of the total value of the iPhone rather than a percentage of the total value of the interface alone, of the then 16 little icons, now more, as icons have gotten smaller and phones have gotten bigger, that you see on the face of the phone. The United States Supreme Court held that there should be an award of profits, but only as a reasonable royalty on the profits that were attributed to the display, leaving Samsung with a large judgment against it, but much, much smaller than the huge amount Apple had claimed. Another limitation relates to FRAND, fair, reasonable, and non-discriminatory licensing of standard essential patents. International standards have become of ever greater importance during the 21st century, particularly in the area of Internet of Things, in which interoperability is essential. A good example of the benefit of international standards is the ability of mobile phones to roam worldwide and to connect with Wi-Fi routers and Bluetooth devices anywhere. Several decades ago, it was realized the best technical approach to a standard often was protected by one or more patents, which in English we call standard essential patents. Further, it was understood that requiring use of a patented technology to meet a standard would give undue bargaining power to patent holders. Another related problem was that of patent stacking, the situation in which compliance with the standard would require licenses from a number of different holders of standard essential patents. Luckily, under pressure from governments and due to their own good sense, leading standard developing organizations have adopted a policy of refusing to create standards requiring the use of a particular patent unless the patent holder would agree to contract to license the patent on reasonable non-discriminatory terms. There's a very useful European Union directive dealing with this issue. While that directive has clarified law in the United States, the law is still unclear in the United States. As many of you know, the United States judicial system has both a central Supreme Court and regional federal courts, I believe 13 different federal courts, including the Federal Circuit, which has the broad powers to consider patent appeals. However, many issues come up in other federal courts and might even come up on rare occasions in state courts. Those state courts have no jurisdiction over patent infringement. Very often, the law will remain different in different federal courts and the different federal appellate courts until the Supreme Court takes a case and decides the question one way or the other. Some of the federal courts have intervened to set fair and reasonable royalties on these inventions that have found their ways into standards by using the criteria for awarding reasonable royalties adopted in the Georgia Pacific case in 1970. A very different approach was taken in a recent case involving mobile phone patents, HTC versus Ericsson. In this case, Ericsson had signed a contract promising to give fair, reasonable, and non-discriminatory licenses with the relevant standards setting organization. However, this organization was in France, and the contract contained a clause stating that it was governed by French law. Thus, this case was not a patent infringement case. The case involved a dispute over whether the license terms offered by Ericsson to the mobile phone maker HTC was indeed fair and reasonable or not. In other words, it was an ordinary contracts case involving the rights of a third-party beneficiary to a contract. Further, it was one involving those rights under French law. Contract cases
Я даже, да, я только не знаю, что делать, потому что если они не поменяли,
Я прошу всех отключить микрофоны. Пожалуйста, Питер.
Весной этого года у меня были лекции по скайпу. И очень интересно было слышать, как профессор частные разговоры разных студентов, которые забыли выключить микрофоны. Сейчас вернусь. После After an expert testified on French law, the court instructed the jury on the rules of French interpretation and read to them an English translation or the English version of the language of the contract, which was very vague and general. It just said you had to give fair and reasonable non-discriminatory royalties. and left the decision on the royalties completely to the jury. Obviously, this approach, while perhaps correct from the point of view of contract law, raises some serious questions from the point of view of unification of law already on the national level of the United States, not to speak of on the international level. It occurs to me that the various organizations should provide more detailed contracts and perhaps even a choice of court or a limited choice of courts rather than merely having vague language that necessarily will be interpreted differently by courts in different countries. Now I'll turn to something we don't have in the United States, to the protection of utility models, i.e. of improvements lacking the major inventive step needed for patent protection. Other countries, for instance, our own country, the United States, where the Constitution requires an inventive step, do not offer protection for utility models. Countries where Parliament has more general powers to regulate intellectual property do. Thus, the United States cannot join any international agreements protecting utility models, and improvements in the United States are protected more by the temporary advantage that the first company to market gets. And this advantage can be substantial, as in the case of Tesla, which brought the first affordable and practical electric car to market. Turning now to product design, various countries offer protection to product design, but despite the undoubted importance of encouraging products that are not only useful but are also beautiful, there are problems with design protection. One problem, like the problem with the huge utility patent portfolios discussed above, is that design patent portfolios may create undue barriers to entry by small competitors. Another problem, which has found different solutions in different countries, is that of repair parts. If one front fender of a car is damaged in an accident, I will want a fender that not only keeps mud from flying toward the windshield, but one which also matches the other fender. If there can be a design patent on automobile fenders, I or my insurance company will have to pay a monopoly price to repair the car. Some countries have partially solved the automobile repair problem by denying design protection for parts of a car that are normally not visible, such as carburetors. This repair problem is a question I'll return to as cars increasingly become machines with fewer and fewer mechanical parts and more software. And the question is how a mechanic can repair the software. I am lucky because my car is 32 years old and I have a very reliable 72-year-old mechanic who knows exactly how to fix it. But things are going to change in the future with gigabytes of software in every car. Turning now to living things, genetic engineering has revolutionized the protection of a variety of living things. At one time, intellectual property protection of living things was limited in the United States to plants that could be reproduced with the same genetic materials, such as by grafting. With advances in science, this protection has been broadened internationally to include seeds and genetically engineered life. It is often said that genetic engineering will be, for the 21st century, the advance that computerization was for the 20th century. One can expect many new issues to arise, in particular the complex ethical and practical issues of genetically engineered human beings. I just mentioned some issues of protection of design of spare parts for automobiles. However, these issues pale in comparison with the possibility of genetically engineering replacement limbs and organs for humans. I now like to turn to trade secret law. The extensive replacement of hardware by software is revolutionizing trade secret law. Thieves and disloyal employees no longer measure individual parts with a ruler or photograph design drawings. They download hundreds of gigabytes of programs and data to flash drives or remote servers. A notorious example is the case involving Google, Uber, and Anthony Lewandowski, the former head of Google's self-driving car program. Mr. Lewandowski defected to Uber, taking a huge amount of software and data with him. In an arbitration of the terms of his employment, Lewandowski was ordered to pay Google $179 million. His new employer, Uber, agreed to pay Google $245 million to settle a lawsuit. Lewandowski also was convicted of the federal crime of trade secret theft, but was pardoned by President Trump after lobbying by a major contributor to the president's campaign fund. Another problem has been the expansion of trade secret theft from individual actions by disgruntled employees to coordinated actions by nation states in the ever-intensifying atmosphere of economic competition. The vastly increased size of trade secrets, thefts, and the emerging role of national intelligence services has led to much more active enforcement and, as noted above, unfortunately, the politicizing of trade secret enforcement. Trade secret law presents special problems for business operating internationally because of the difference among countries in the laws concerning the qualification of information for trade secret protection and in laws regulating employer-employee relations. Now I'd like to turn to copyright, and I'd like to discuss what I see as 4 major negative trends in copyright law. First, the growing number of surprise copyright violations in which someone inadvertently uses or distributes copyrighted protection material. Second, the emergence of an ever-growing number of orphan works whose uncertain copyright status prevents their use. Third, the extension of copyright to computer software. And fourth, the overexpansion of rights of copyright owners by anti-decryption legislation. I'll discuss these problems and some of the attempts to solve them, attempts that have succeeded in some ways, failed in others, and in other ways have just been proposed. First, I will turn to what I call surprise copyright infringement. This can occur in 2 ways. One, due to a misunderstanding of the complex rules or relevant facts bearing on copyright ownership, or alternatively, and much more commonly, due to the uploading by users of unauthorized copyrighted material to social networks or other websites. Over 30 years ago, the United States Supreme Court provided for leniency for an infringement caused by a misunderstanding of complex rules. In the case of Stewart versus Abend, the court held that there was no automatic right to an injunction, and the Supreme Court decided the copyright owner could only recover reasonable warranties for the surprise infringement. This saved the famous movie Rear Window, to which the fantastic contribution of the director Arthur Hitchcock and the lead actor Jimmy Stewart were far greater than those of the very mediocre short story they thought they had a license to. There is now an ongoing debate worldwide over a related problem, that of a surprise infringement caused by infringing material uploaded by users to social networks or other websites. Obviously, the users of social media and other websites are liable themselves for uploading infringing material, but such users are often anonymous or are teenagers or others lacking money to pay damages. And they may be out of reach in distant countries. Thus, the debated question is whether copyright owners or website maintainers are or should be responsible for policing such uploaded material. In the United States, a solution very favorable to the social networks and other major websites such as YouTube was found in the Digital Millennium Copyright Act, which placed the burden of policing upon the copyright owner while freeing the website maintainer from damages if it takes down infringing material upon notice from the copyright owner. It may be time to re-examine this allocation of responsibility in light of the increasing availability of digital search techniques for finding infringing material. The 2019 European Directive on Copyright provides for a more balanced, much more complex approach to the allocation of the burden between the websites hosting uploads and the copyright owners. I do not foresee international unification anytime soon, and this may create problems for social networks and websites, which may have to invoke different policing systems in different countries or attempt to black out their websites for certain countries. Second, I will discuss orphan works. These include works in the public domain whose status cannot be determined easily, and also copyright protected works whose owners cannot be determined easily. A large problem was caused when the last major holdouts, namely the United States and the Soviet Union, adopted the Berne Convention, and when this convention was enshrined in the World Trade Organization TRIPS agreement on trade-related aspects of intellectual property rights. The accession to the Berne Convention has created a huge and ever-growing number of orphan works. And I wonder if the United States has made a serious error in abandoning its longstanding system, which put published works in the public domain immediately upon publication if they lacked a copyright notice, and otherwise after a relatively short 28 years if the owner failed to file for renewal. Under that system, anyone could determine the copyright status of a published work merely by checking for a copyright notice. The system effectively prevented the emergence of orphan works and achieved what many thought was a good balance of incentive for creation and the public interest. The great scientist Isaac Newton, in a 1675 letter, made the famous statement, If I have seen further, it is by standing on the shoulders of giants. Given that all new creations rest on earlier creative efforts by others, it is only appropriate that there be a balance between incentives and the public domain. That balance is now put in doubt in two ways. First, by creating uncertainty as to the ownership and end date of copyright, and second, by creating an excessively long term. The excessively long term of the Berne Convention has been made even longer by legislation in many countries, including the United States, extending the term well beyond that required by the convention. A possible compromise to orphan works could involve several approaches. Some of these might not require renegotiation of the Berne Convention. Others might require the extremely difficult and perhaps impossible task of revising the convention. A few steps have already been taken in the United States. Numerous countries in the European Union have considered reforms to deal with the orphan works problem. There is a survey now a little out of date in a 2015 report of the United States Copyright Office, which I cite in a footnote. Many of the proposed and adopted changes, however, are very timid. They do not come close to solving the problem. Typical proposals would restrict remedies to reasonable royalties if the copyright owner had made a diligent search if the copyright user had made a diligent search for the copyright owner. This reverses the principle applicable in many other areas of property law. For instance, laws concerning transfer of immovable property, which place the burden upon property owners to ensure that their ownership is reflected in public records. It is contrary to the universal approach in patents and the approach of most countries to trademarks, which places a similar burden on owners of these types of intellectual property to register their ownership. The problem with the reasonable or diligent search requirement is there is no easy way to define what constitutes a reasonable search, and a thorough search may be extremely expensive, though recent developments in searching at least makes it much simpler than before to search information that is on the internet. Another suggestion has been to retain the present length of copyright protection, subject to a requirement of renewal at short intervals, such as every 5 years, by filing a renewal form and payment of a small fee. This would undoubtedly put the vast majority of copyrighted material into the public domain. However, it would be difficult or impossible to implement in a way that would not violate the Berne Convention. And we must remember the Berne Convention is enforceable through the World Trade Organization's dispute settlement procedure. And one important development for international enforcement of international property rules is the decision by the United States new president to return to those settlement procedures. Third, I will discuss problems raised by the extension of copyright software protection. Such protection is in conflict with the long-standing principle that copyright should protect only literary and artistic works, while useful works should be protected by patent, and then only if they involved a significant inventive element and only for a relatively short period after a fully enabling disclosure. Further, in the case of patent devices, patent protection in general, nothing prevents other businesses from making devices compatible with patent devices or repairing patented devices. However, copyright can hinder such independent matters. In the United States, both Congress and the courts have put some limits on the overbreadth of copyright protection, but many problems remain both here and around the world. In a leading case, Google LLC versus Oracle America, the United States Supreme Court gave a very broad interpretation of the principle of fair use embodied in the United States Copyright Act to allow Google to copy over 10,000 lines of Oracle's code for the Java language so as to ensure compatibility of Google's Android software. The Supreme Court, however, did not decide in this case the question of whether there could be software in something that was purely of utilitarian practicality. However, it is far from clear that other countries whose legislation limits fair use to a fixed list would reach the same result, or how this question would be treated by the World Trade Organization. An encouragement in development in copyright law has been the worldwide recognition of free and open source software in legislation. For instance, in the European Union Copyright Directive and in court decisions in various countries. Much more work now, however, needs to be done to remove uncertainties in this area. A fourth problem area is that of restrictions on access to encrypted and password protected copyright information. While such restrictions aid greatly in the fight against the piracy of books, music, and video, they also limit traditionally permitted uses of copyrighted material. A good example of the problems created by these restrictions is that of the Digital Millennium Copyright Act in the United States. This act prohibits breaking the encryption of copyrighted material, but also gives essentially legislative powers to the Librarian of Congress as head of the United States Copyright Office, the power to proclaim on a regular basis the list of exemptions to this copyright anti-encryption protection. Most recent list was published last month in October 2021. It retained many of the prior exemptions aimed at uses for critical comment, education, and handicapped access. It also substantially broadened exemptions for circumvention of encryption for repair, which previously applied only to motor vehicles, broadened it to include all consumer products. Current litigation is ongoing on the question of monopolization by Apple of the process of sale of cell phone applications and of using its powers over iPhones to obtain 30% of payment for upgrades for applications. The leading case, which is currently in the courts, is Epic Games versus Apple Incorporated. Another question is the scope of the power to modify software to make it work. Some rights to this are included in the US copyright law. A referendum in the state of Massachusetts approved extending the right of repair to include modifications and repair of automobile software downloaded to automobiles over the internet. as well as that bought initially by the consumer. As the software component of consumer goods becomes ever a larger and larger percentage of what makes that goods work, the right to repair is going to become ever more debated, and we can expect more legislation both on the state and the federal level in the United States, and more legislation in other countries to try to balance the right to repair and a right to modify and a right to make compatible devices. Now I'll turn to trademark. The 20th century was marked by successful efforts to simplify the international trademark registration process and to broaden the protection afforded to trademark owners. The Madrid system has simplified and reduced the cost of registering trademarks in multiple countries. An idea first developed widely in the United States and now recognized to some extent in the TRIPS agreement is that of protecting trademarks against dilution by blurring or tarnishing their reputation by the use of the trademarks on completely different types of goods and services. However, the combined result of the continued registration of more and more products, not trademarks for more and more products, not only at the country level, but also at the international level, and that of making trademarks broader in their scope so as to prevent the use on quite different goods, has created a serious new problem, that of the increasing unavailability of good, what I would call good trademarks. A business that wishes to market a new product is likely to encounter problems in various countries, both of previously registered marks for identical or similar goods and of marks registered for quite different goods by large companies that can afford to litigate to protect their products from so-called dilution. By lack of good trademarks, I mean the shortage of trademarks, particularly word marks that are short, memorable, and convey a positive feeling. A recent extraordinarily thorough empirical study shows that such trademarks are becoming increasingly less available, particularly for products to be marketed internationally. This situation can create and is creating an ever-growing barrier to entry by new firms in a market dominated by older established businesses with easy to remember marks. And I refer you to this very detailed study, which goes far beyond what I can summarize with a footnote in the available in the document on the website referenced in my chat. Two other areas of trademark law are likely to be of importance in the 21st century. The first involves the delineation of trademark protection from patent law. Trademarks in the United States, and I believe almost everywhere, can last forever if necessary formalities such as renewal are observed and if they keep being used in practice. However, we should not have permanent protection of useful or functional features, i.e. features that require an inventive step. Such protection should be limited in time. Drawing the line between trademark protection and patent protection is not easy, and it has led to extensive litigation in the United States, for instance, where companies have resisted claims of trademark infringement by saying no, they were taking not the just the words of the trademark, but the useful features of the trademark, and that the trademarks were invalid to the extent they cover useful features. To date, the appellate federal courts in the United States are split on this question, and the Supreme Court has not ruled on it. Many other countries have not faced or just beginning to face the question. A second question is the line between trademark protection and freedom of speech. Should protection be denied to trademarks that offend some customers, or should trademark protection be granted to marks, leaving the marketplace to decide if customers would be so offended that they should not buy the product, would not buy the product? The Supreme Court of the United States has left that question to consumers, not to the Patent and Trademark Office. How free should critics and competitors be free? How free should they be to make negative comments on products or do comparative advertising referring to others' products? Again, there are differences, not so much in the federal courts in the United States, but between countries. Next, I'd like to turn to some areas closely related to the main branches of intellectual property law. I do not consider it really to be important whether particular countries would label these areas as intellectual property or not. What matters is that many of the issues emerging in the 21st century with these areas raise the same questions as I have discussed today with respect to intellectual property. Internet domain names have much in common with trademarks. Indeed, in a ruling in the very recent case of booking.com, the well-known hotel reservation site, United States Supreme Court ruled a domain name could function as a trademark. Unfortunately, the way that the domain name has developed on the internet has resulted in a violation of a basic principle of trademark law, because competition can flourish only if their competitors can use the generic names of products. It is a universal principle of trademark law that no one can have trademarks in the generic name of a product. No one can have a valid trademark in beer or restaurants or surgery in those words. However, on a first come, first served basis, in the days of the .com gold rush, astute speculators captured thousands of generic .com domain names, particularly in the English language, such as weather.com and hotels.com. Indeed, the same study I just cited about the exhaustion of the supply of generic trademarks, found that the supply of generic domain names was also largely exhausted in the .com domain. A major attempt was made by the organization that administers domain names to eliminate this problem by instituting a series of generic top-level domain names. Many of these domain names corresponded to generic words such as beer or restaurants. Some, such as beer, are open to all. Others, such as Archie, are limited to a particular business. Speculators have created hundreds of these new top-level domains. However, in 2013, just before the new system was launched, an article in the authoritative publication, The Guardian, correctly predicted in 2013 that the new system would fail. The system has been a total failure. Businesses have found that they must have a .com name to succeed on the internet. Thus, the problem of monopolization of generic names remains. And because of vested interests, it is generally too late to consider what could have been a solution, namely allowing all businesses in a particular area to share a generic .com name with links to their particular site. In some countries, businesses make wide use of country-specific top-level domains, such as .ru for Russia. The exhaustion of generic names in such country-level names is a ripe subject for empirical research. I noticed, for instance, that the well-known vodka, Ruski Standard, has cleverly obtained both the vodka.com and vodka.ru domains for itself. A Polish liquor company has not only captured the website vodka.pl, but is selling vodka with the trademark vodka.pl. A more appropriate use of a liquor site is the site cognac.fr, which is owned by an association of grape growers, distillers, and marketers of the beverage, all of which have the right to use the famous appellation of origin. And I'm sure the site's managers would instantly bar any attempt at placement of information on the site by other makers of brandy. Now I'll turn to the right of publicity. The right of publicity, i.e. the exclusive right of individuals to allow use of their name of identity for advertising purposes, has been recognized for decades in the United States. The right serves as an important source of income for famous and entertainers and athletes. In the United States, the right is recognized in most, but not all states, by common law, statute, or both, and is indirectly registered.
Нет, здесь сейчас будет переводчик, смотри.
And in the United States, the right is recognized in most states by common law, statute, or both. However, most other countries do not recognize this right directly, though many may protect the right indirectly by use of people's images. Numerous questions concerning this right remain open for resolution in the 21st century. As a matter of economics, the right allows celebrities to maximize the income from their personas by avoiding both underutilization and overexposure. A natural rights theory suggests that each person should enjoy the benefits of their achievements, such as the extensive effort required to succeed at sports. But is making the rich richer an appropriate goal for the legal system? Should untalented but good-looking persons be given the chance to turn their appearance into money? How about persons who have no particular achievements or good looks? Should they have a right to publicity? Should it pass by inheritance? Should it be something that could be sold, be attached by creditors? Should the right attach only to images or also to a voice? This and numerous other questions have been litigated in the United States. Thus, as long as these questions remain debated in each country, it's going to be a long way until we get to international agreement on protection. As my last topic, I'd like to discuss a new area of intellectual property, that of non-fungible tokens. This is a highly debated area. Typically, what is done is an element in a blockchain, most often Ethereum, is linked to a particular virtual object, such as a digital image or a document, such as a contract. And unlike ordinary coins in a blockchain and of cryptocurrency, such as Bitcoins or Ethereum coins, which are fungible in the sense that one Bitcoin is completely equivalent to another, just as a dollar coin is equivalent to any other dollar coin, or a ruble coin is equivalent to any other ruble coin. These non-functional coins are unique and point to only a single digital image or a single document. Ethereum has defined official standards to ensure the unique nature of the way in which a non-fungible token in its blockchain points to a unique item. However, there are numerous outstanding legal and practical issues. Non-fungible tokens are currently taking the digital art and collectible works by storm. Digital artists are seeing their lives change thanks to huge sales or of individual works, or sales for huge amounts of money to a new audience. And celebrities are joining as they spot a new opportunity to connect with fans. But a major question remains with non-fungible tokens and other new forms of intellectual property that will be invented in the 20th century. Are they really useful innovations, or are they primarily new ways of defrauding the public? Such fraud has long been a problem in traditional forms of intellectual property. For instance, vanity presses that promise unpublished authors fame and fortune from their copyrights, but which end up charging exorbitant fees for insignificant results, or inventor assistance firms which charge amateurs for advice, but almost never end up creating a valuable patent. I've cited a comprehensive article warning of the numerous possibilities of fraud and various cases of existing fraud, such as the disappearance of an organization that collected $2.7 million for pictures of monkeys and then disappeared with the money, and efforts by a copyright owner to force a takedown, which succeeded, of a sales platform that had sold millions of NFTs pointing to artworks of the copyright owner, but without the permission of the copyright owner. In closing, I would like to discuss a serious emerging problem which has been emphasized by the world in now facing the COVID pandemic. In the world economy, the richer countries have tended to be producers and exporters of intellectual property and users and importers of raw material, while the poorer countries tended to be producers and exporters of raw material and importers of intellectual property. This imbalance has been partially rectified by the OPEC plus oil cartel, but in the long run, the use of local renewable energy sources in the richer countries will restore the imbalance. This imbalance, to a large extent, is built into the World Intellectual Property Treaty System and the TRIPS agreement. And during the COVID pandemic, the effect has been particularly evident. rich countries have been able to pay for huge quantities of vaccine, but have been very stingy in delivering free vaccines to poorer countries and in aiding with vaccine distribution works. There is no doubt that the intellectual property system, along with government support of science, has worked wonderfully, encouraging the safety and effective development of vaccines, and now the promising development of effective medications to treat the disease. The difficult task of remaining is to maintain really effective for inventions while finding a way, particularly in the area of health, to bring these inventions to all those susceptible to epidemics. Thank you very much. Спасибо за внимание. I'd be happy to answer questions. Готов отвечать на ваши вопросы.
Спасибо, профессор Мэггс, за такой блистательный совершенно доклад. Я думаю, что выражу общее мнение, если скажу, что вы просто открыли нам перспективы развития сферы интеллектуальной собственности на много десятилетий вперед, показав, насколько широк круг объектов интеллектуальной собственности. И у меня, конечно, сразу возникла масса вопросов. Ну, например, вы говорили об NFT-токенах, что это следует рассматривать как новый объект интеллектуальной собственности. Или право на изображение, которое является личным неимущественным правом любого физического лица. Это тоже новый объект интеллектуальной собственности. Может быть, нам тогда пересматривать помимо Бернской конвенции еще и Стокгольмскую конвенцию об учреждении ВАИС. Это очень интересные идеи, мне они очень близки, очень интересны. Поэтому, но я не хочу отнимать возможность у других участников задавать свои вопросы. Поэтому вот Светлана Викторовна Бутенко написала, она из Томского университета, она написала вам довольно большой вопрос. Пожалуйста, он в чате, вы можете его прочитать, он по-английски написан. Хотя я знаю, что вы прекрасно владеете русским языком тоже. Сказать трехмерных торговых знаков.
Three-dimensional trademarks is the first question. Oh, just a second. This is a very difficult question in the United States and is related to the question of functionality I talked about. And the Supreme Court early on decided a case involving two Mexican restaurants. And the first Mexican restaurant said its decoration was a trademark. Mexican restaurants tend to use colors and design typical of buildings in Mexico, just as Chinese restaurants often have red lanterns and golden dragons. And the question was whether they could get a trademark protection for the decor of the restaurant. And the Supreme Court, in a dubious decision, decided they could. Next, a company sought trademark protection for its clothing and the design of its clothing, which was three-dimensional. And the Supreme Court said, yes, it could, but no matter how unique the design, it could only get trademark protection if it showed consumer recognition and identification of the mark with that particular company. Meanwhile, the Federal Circuit, which has jurisdiction over appeals from a denial of registration of trademarks, considered a spray can, such as like a bottle with a trigger and which you can spray your computer screen to clean it off, or spray the windshield of your car, or spray your kitchen counters. And it said that while each of these features could be protected, was potentially protectable by a trademark, the combination was not, because many other combinations were available. The Supreme Court then considered a case, and I apologize for being long in this, but as you know, we have a traditional 50-minute academic hour, and any professor can talk on 50 minutes on any subject. The Supreme Court considered a case involving a traffic sign which was held up by two springs, and there was an expired patent on the two springs. And not surprisingly, as soon as the patent expired, a competitor copied the design. Exactly. One would think this was a very simple case of patent law. You copied my expired patent. Yes, I did. That is what an expired patent is for. You dedicated your invention to the public when you took a patent. Obviously, a sign can't be kept as a trade secret, so the company had no choice. The Supreme Court ruled that because the design had been patented, it was functional and could not serve as a trademark. The United States Court of Appeals for the Federal Circuit, when the next case came up, said, well, the Supreme Court didn't really mean that. And now the circuits are split as between whether the Supreme Court really meant that you can have a combination of functional features, here two springs, which could be patented, of course, because it kept the signs from blowing down, but could not be protected by trademark, or whether the Federal Circuit says you should always consider different combinations, even if the combination is the subject of an expired patent. And at present, we have a vast split among the circuits. Indeed, I made up a case of this and put it on my examination for a trademark law last spring.
Так, следующий вопрос там есть еще.
Anti-monopoly, antitrust remedies in the United States against patent abuse in pharmaceuticals. This is a complex question. The United States spends a lot of money on supporting science. It has what is called a march-in provision, that if it supports an invention, the entity, whether it's a university or a company that makes the invention, can get the patent, but the United States may, if it wishes, march in and take itself a license for the patent or issue licenses for the patent. There's now active discussion whether the United States should march into the Moderna patent, which was aided by the US government in its development. And so it has an actual right to march in. With respect to other patented drugs, the United States generally does not march in. A company may act on its own. For instance, Pfizer, which is about to seek US permission for a pill that will cure COVID miraculously. You take one pill a day for a week and you're cured. It's amazing. In the preliminary tests, has indicated that it will allow some factories in developing countries to make this pill royalty free, because it got into a lot of social pressure on the limited distribution of vaccines. The most important issue, and one now under consideration by the present administration, is a rule that the government will not bargain in buying medications for older citizens. Almost everyone in the United States over 65 is governed by a public medical system called Medicare. And even the most right-wing of critics who are constantly telling the government that it is in danger of falling into socialism or communism say we want our Medicare protected. And a clause in the Medicare law says the government will not bargain on price with drug manufacturers. Every other government, the French government, the German government, the Russian government, if it needs to buy a patented medication, will immediately bargain on price and say, well, there are 3 pills that will cure this disease. And we would like to tell you we're bargaining with the other 2 companies and you had better offer us a good price. Insurance companies bargain, hospitals bargain, the government bargains for buying medicine for the Army and Navy, but it doesn't bargain in this area. So it is not so much the use of antitrust medication, antitrust in medications, but the bargaining power. Now, if say Pfizer and Moderna tried to, which have the 2 leading vaccines, tried to join as one company, you would apply the normal relevant market analysis and stop that merger. There's no doubt about that. But as long as the companies remain independent, we don't see antitrust law being used.
Так, еще один вопрос от того же участника. И вот здесь, я думаю, надо
inequitable conduct.
Поскольку речь касается и Роспатента тоже. Пожалуйста.
Inequitable conduct is continuing and it is still possible. Good patent attorneys, of course, are very careful to avoid any hint of inequitable conduct because they would lose their client's patent. I remember some 10 years ago, I was invited to give a talk on something about patents in Japan, and I gave a talk on inequitable conduct in the US Patent Office with many, many examples and cases. I gave each lawyer who attended the talk several hundred pages of materials, and they were very happy because they wanted to be thoroughly familiar with the US practice, since most big Japanese companies also take out US patents. And of course, Russia has general clauses on abuse of right, but I think it would be a very good idea to have specific rules in the patent law on inequitable conduct. But it's very much alive and well. Any other questions?
Пожалуйста, есть ли еще вопросы прямо от микрофона, пожалуйста.
Можно прямо на русском языке. от микрофона.
Можно мне, Михаил Александрович? Руслан Бедник.
Да, пожалуйста.
Здравствуйте, уважаемый профессор, большое вам спасибо. У меня вопрос следующий. Прошу вас пояснить мне логику, по которой в DMCA, Digital Millennium Copyright Act, включены положения в Title 5 по охране корпусов судов, Vessel Hull Design.
Это интересный вопрос.
Спасибо. Да, это вопрос, да.
20 лет тому назад, забываю точно когда.
Питер, можете по-английски, у нас прекрасные переводчики.
20 years ago, I forget when, 2 states adopted laws protecting vessel hull design. Then 2 cases went to the courts, one saying the law violated the constitutional provision giving the federal government a monopoly on patents. And the other state or other court saying, no, it did not violate the Constitution. The case went to the Supreme Court, which said it did violate the Constitution. But as you know, in countries with a free market economy, the lobbyists for big companies never give up. And if they can't go in through the front door, they go in through the back door. So the lobbyists, once the Supreme Court had given the final decision that vessel hull design could not be protected by state law, the lobbyists began to lobby on putting this strange rule into federal law, which seems to violate the basic idea that you need an inventive step to get a patent, because it basically gave a patent without an inventive step based on the method of copying. Now, so that's the history. And one could do a study, which would take me not 50 minutes, but 50 years to talk about lobbying in intellectual property legislation in the United States.
Понял.
Спасибо, Питер. Так,
Спасибо
еще
большое.
вопросы? Пожалуйста. Микрофоны открыты. Вы включаете свой микрофон и задаете вопрос. Так, пока еще вопросы не готовы, тогда я хотел бы задать вопрос Питеру, возвращаясь к тем вопросам, которые я сказал в начале. Дорогой профессор, скажите мне, пожалуйста, как вы считаете, вот NFT-токены – это новый объект интеллектуальной собственности?
Yeah, I think it could be called an item of intellectual property because it really has no physical existence other than temporarily in the memory of these computers in the blockchain, which one would hope is suitably backed up. It certainly is not physical property, like in the old days, a gold coin was physical property. You can't touch it, you can't feel it. Both the digital art and the token that points to the digital art are elements. Digital art is an element of human creativity. The token is merely a way of trying to make this unique. If we think of the famous and extremely expensive etchings by Picasso, after making a etching plate and printing and signing 50 copies, he then destroyed the plate because he could maximize the value of his work not by making one copy, and not by making a million copies, but being an astute businessman as well as a great artist, he had figured out that making 50 copies is optimal. He could have decided to make one copy and destroy the plate. And I see no difference in Picasso making an etching, making one copy and destroying the plate, and an artist making a digital image and making this one NFT linking to it.
Но, может быть, тогда поставим вопрос таким образом. NFT-токен – это новый объект авторского права.
The object of авторского права, the object of copyright law, or I'm not sure if we can call it copyright law, because it could point to, it can also point to something for which there is no protection because it is not creative, such as a contract. But the object, I think, of copyright is the digital image, which may be a static image or a changing image, but motion pictures are a changing image. So the image is the object of copyright. And it seems to me, though I haven't really thought about this thoroughly, and I think we need a lot of intellectual property people to think about it, is the fact that no more copies of this kind can be made, just as once Picasso has destroyed the etching, you can't make another similar, you can make a photograph of it and so forth. The difference, and this is what leads to the fraud, is that anyone can make a, if Picasso had lived to make a digital picture, and he was always experimenting in new media, so I'm sure he would have made great digital pictures. Anyone, including any cyber criminal, could make a token pointing to a copy of that digital picture and try to sell it as an original Picasso. And that is, of course, anyone can make a pirated copy of a movie, and there are a number of websites that are quite successful in selling pirated copies. So it is not a very different problem.
Я так понял, что
I got a
у
question.
заместителя руководителя Роспатента есть вопрос?
Совершенно верно, совершенно верно.
Да.
Спасибо огромное за предоставленное слово. Спасибо, доктор Мэггс, за такой широченный охват вопросов сферы интеллектуальной собственности. Честно говоря, я даже не мог представить, что за такой короткий, в общем-то, отрезок времени можно так много рассказать об интеллектуальной собственности. На самом деле это могло бы занять несколько часов. Но у вас получилось. Я бы хотел задать вопрос, вернее, поделиться сначала своими соображениями, но и задать вопрос, а как это в США? Мы в России часто сталкиваемся с ситуацией, и это вопрос о фарм-индустрии, такой серьезный вопрос, связанный с серьезными лекарствами, когда фармкомпании говорят нам, что их права нарушаются, права на созданные ими лекарственные средства нарушаются со стороны дженериковых компаний. Эти дженериковые лекарства регистрируются и продаются на рынке. И к нам обращаются компании и иностранные, и российские крупные предприятия с просьбой как-то наладить эту ситуацию, изменить ее и помочь им защитить их права от недобросовестных конкурентов. Мы в нашей стране этот вопрос с правительством обсудили, дали предложение и считаем, что одним из решений подобной ситуации, ну, подобных правонарушений, которые, конечно же, можно разбирать в суде, но для того, чтобы сделать этот процесс менее длительным и более содержательным, наверное, чтобы можно было к чему-то обратиться и установить истину быстрее, чем, наверное, это в судебном процессе происходит, мы решили сделать некий такой фармацевтический реестр, в котором были бы внесены сведения о правообладателях из наших патентных реестров, сведения о патентообладателе и соответствие с международным непатентуемым наименованием МНР, тот, который в ВОЗ находится, Всемирной организации здравоохранения. Вот мы решили сделать такой реестр. Это цифровое решение, безусловно, но это цифровое решение в помощь решению правовых вопросов для защиты прав на интеллектуальную собственность. Вот там, через какое-то время, безусловно, мы этот реестр создадим и запустим. Есть уже его прототип. Сейчас просто тестируем. Но я хотел уточнить ваше мнение, насколько это может быть эффективно действительно и для России, для всего мира, и как в США подобные вопросы, я уверен, они есть. Тот же самый Orange Book существует. Вот как в США эти вопросы решаются? Спасибо. У меня еще будет два вопроса.
Yeah. This is a difficult question. The United States, on the one hand, negotiates as a very large exporter of intellectual property, negotiates very hard in international fora for a high level of protection. When it makes trade treaties, it not only asks for normal protection, it asks for TRIPS plus protection. TRIPS plus is for the United States what OPEC plus is for Russia. So it is very strong in doing that. On the other hand, its domestic protection is often weakened by many of these court decisions I have discussed. And the United States is very reluctant to give up any of its powers to judge what should be patented and what shouldn't be patented and so forth. And thus, it's very hard to get US cooperation. One thing the United States has done in recent years has adapted patent legislation and then in late 2020 trademark legislation to make it easier to get bad patents and bad trademarks off the book and to get them off sooner. So whenever you talk about these bad faith things, you need definitions of what is bad faith and so forth, but you also need procedural mechanisms that achieve a good balance of speed and fairness. And that is quite difficult sometimes. But, and we'll see, it's really too early to know how the new mechanisms in trademarks are working in the United States. The United States law is quite clear on comparative advertising. You can advertise your product just as effective against something as against X. And unlike most countries in Europe, which restrict advertising of pharmaceuticals that are available only on doctor's prescription, American companies advertise heavily on television that our medicine is a better medicine for this disease than medicine X of some other company. And they give the name of the other company, the name of the other medicine. So we have very active attempts, but also we keep lawyers busy because if you say anything false about the other party's medicine, of course, they will sue you immediately. I may have strayed a bit from your question, but I think it's very important to think about procedural mechanisms, whether it's this procedural mechanism or some other procedural mechanism.
Питер, появились еще вопросы в чате. Пожалуйста, посмотрите. Вот здесь сразу два
Okay, someone asks about protection of intellectual property in the university.
Да.
Here we have to look at different kinds of intellectual property. I can go to Russia and give talks. That's my intellectual property. I can write books and publish them and keep the royalties, if any. I can however, I can't use the university's trademark name in selling goods or something like that. There was a problem some years ago. Some company wanted me to lead a tour of lawyers to Russia using the name of the university. And the university has competing tours that it runs. And it did not want to let this company use the name of the university. For patents, there is a very special procedure in which a professor who invents something must file a disclosure with the university. And then the university has a consultants who decide if it's worth the cost of patenting and if the university should patent it, in which case the inventor gets a percentage of royalties, or if it should give the rights to the professor who invented it and say, we don't think it's worth patenting, but if you want to get a patent with your own money, you can do it. And some things are patented, other things are professors get patents with their own money, which may succeed or fail. I once got involved on a committee, which I didn't want to be on, trying to settle a dispute between two professors as to who really invented something. The university also has a copyright expert who decides issues of copyright. And in particular, before everything was distributed on the internet and the university sort of lost control of it, before the university's copying service would copy materials for students, they might check with the university's copyright czar. So we have a very active thing. A recent development in the United States has been a lawsuit by sports players, particularly football players, who took a case to the US Supreme Court and won on invalidating an agreement by the National Collegiate Athletic Association, which said that universities could agree to limit the amount of financial aid given to athletes. And they won the right to say if the aid went for educational purposes, there couldn't be a limit. Furthermore, they have lobbied in state legislatures, and states are very rapidly passing laws saying individual athletes cannot be prevented by contract with their universities from selling their right to publicity by endorsing products. Previously, the National Collegiate Athletic Association was making a lot of money selling these rights of publicity and paying its administrators $500,000 or $1 million a year, while the students got just enough money to eat and buy textbooks. And the unfairness of this situation has led to rebellion by state legislatures in favor of the students. So that's a rather interesting development. There's also the question of whether the students are really students or are employees with the right to form a trade union and bargain for such things as health insurance in case they get injured on the sporting field.
Да, это хороший вопрос, но там следующий вопрос есть уже теперь
Okay.
касающийся искусственного интеллекта.
Okay, recent precedents in the US legal system. Well, there are two kinds of precedents. There are legislative precedents and there are court precedents. The legislative precedents, I mentioned the development of new ways of getting rid more rapidly and simply of bad trademarks and bad patents. The court precedents, I mentioned most of the recent ones in my talk, and I put in chat where you can get the references to read these on the official websites. And to sum up the court precedents, generally they have been toward weakening intellectual property protection, not strengthening it. And generally, only the very most important questions have been decided by the Supreme Court, and many very important questions are still very much debated at the lower court level because the Supreme Court has given no guidance.
Так, Питер, следующий вопрос про искусственный
My
интеллект.
personal opinion on how one would regulate inventions of artificial intelligence. This is really a wonderful question, and I have been worried about it, that I'm trying to become informed about it, but I'm not yet at the point of a personal opinion. What I am sure is that some companies will sue other companies for violation of things developed by artificial intelligence. Indeed, in that case of Google versus Uber, I suspect that some of the stolen material, which has never been published, was obtained by artificial intelligence. One advantage of trade secret theft, which was that case, is you just have to show it's your material and it's secret. You don't have to show that some human invented it, as you do in traditional patent law. So because of the use of big data by artificial intelligence, almost all the results are going to be trade secrets, and people are not going to publish how they do it, and they're not going to put in patent applications and give an enabling description. Indeed, it would be hard to give one because some of these people don't know how it works themselves.
Следующий вопрос.
Okay.
По поводу долей в исключительном праве.
Okay.
Да, коллеги, здравствуйте. Большое спасибо вам за прекрасное мероприятие. Профессор, большое вам спасибо за такую познавательную, интересную лекцию. Наталья Щербак, Московский университет, кафедра гражданского права. Я знаю о том, что, и мы знаем, что в Patent Copyright Act и в US Patent Act вы выделяете долю и в исключительном патентном праве американцы, и в авторском праве. Мы в России уже подготовили несколько законопроектов, но почему-то эти законопроекты не проходят. Наши специалисты объясняют, что, смотрите, у нас совместное соправообладание. То есть, если не могут договориться, то, по сути дела, мы парализуем оборот. А американцы, наоборот, коммерциализируют свои права на результаты интеллектуальной деятельности. То есть, получается, что у вас правообладатель может распорядиться сам исключительным правом в целом, с последующей кондикционной обязанностью по отношению к другим соправообладателям. Мы объясняем нашим специалистам, что как это хорошо, мы не парализуем оборот, мы даем возможность коммерциализовать, когда такие объекты имеют много соправообладателей. Ни один из законопроектов почему-то не проходит. Дорогой профессор, вы разделяете наши опасения? То есть вот до сих пор у нас совместное соправообладание, мы не разрешаем распорядиться исключительным правом в целом, только нужно прийти к консенсусу. Как вы считаете, правильно мы думаем, правильно ли мы опасаемся этих в исключительном праве? Спасибо большое.
Это сложный вопрос. Sometimes there are disagreements between co-authors. I've had many co-authors, both Russian and American, and we've never had a serious disagreement. And we have never signed a formal written contract even. With publishers, you have a more complex situation. A publisher spends a lot of money promoting the book. And authors want publishers to spend money selling the book. In some cases, a copyrighted work has a short life, like something written about some current event. In other cases, it has a long life. I'm co-author of a book that was first published by the original authors in 1934. The publishing company and its successors have had the copyright since then, and every few years they have invited another set of authors, usually by agreement with the living former authors, to publish new editions of the book. And for about 20 or 30 years, I was one of the authors of the book. So in this case, the book has really a separate existence, which goes much beyond the participation of the authors, and even has provisions in it that deal with succession on death of the author is in the contract. Usually you get half the royalties of the next edition after death, or the heirs get half the royalties of the next edition and 0% of the following edition. And there is in the contract on how long the famous author's name can be used. Because often a book is written by a famous author and then continued by other authors less famous. But in my own experience, at least, I have never had problems working that out. Sometimes I have done stupid things. For instance, in first working on a translation of the Russian Civil Code, I had to buy it back from the American publisher. And that cost me some money. But now that I have it back, I control the publication. And with my co-author, Professor Zhiltsov, we're able to control it separately in Russia and in the United States because of the different publishing customs in the two countries. But I think we can't ignore the role of the publisher because while now anyone can publish any book on Amazon, selling a book is the essence of publication. And you have to find a way to encourage publishers to bring books to the attention of readers. Otherwise, it'll just sit on the shelf. But I would say that the basic thing, which is true in the United States and largely true in Russia, is the key is freedom of contract, and almost all the problems are solved in the United States by freely negotiated contracts. It also helped that I knew personally the head of the publishing company, and he would come from time to time to see me and say, what are your plans? And we would then shake hands, and then the actual physical paper was just a piece of paper.
Наталья Валерьевна, вас удовлетворил ответ профессора Мэггса?
Да, спасибо большое. Вот все правильно говорит профессор, и, конечно, мы тоже понимаем, что речь идет не о доле в книге, не о доле в песне, речь идет именно о доле в праве, при условии, что мы в вечном праве, у нас нет никаких проблем, да, с долями в праве. Мы понимаем, что общая долевая собственность, но почему-то вот или это стереотип, или это наш подход, что вот мы не видим, исключительное право – это имущественное право, право оборотоспособное, отчуждаемое, передаваемое. Какие проблемы выделения долей? Но мне кажется, в патентном праве здесь вообще, наверное, это не проблема. С точки зрения авторского права, может быть, вот этот пул моральных прав, который тут существует, личных неимущественных прав, он как-то вот не позволяет законодателю выделить эти доли в исключительном авторском или смежном праве. Хотя, мне кажется, с точки зрения коммерциализации, вот профессор говорил о стимулах. Но вот если действительно мы не только разрешаем автору получить то, что он вложил в создание, но еще и позволяем здесь ему заработать, стимулировать его дальнейшее творчество, наверное, такую бы возможность можно было бы предоставить. Спасибо большое, профессор.
Moral rights are not very recognized in the United States, and they're certainly transmissible. My contract with the publisher says if the publisher asks me to make a new edition and I don't do it, the publisher can invite a different author to work on the new edition and take my name off the book, or leave my name on the book.
Спасибо, спасибо. Интересно, интересно. Так, еще вопросы. Пришел вопрос от Федерального института промышленной собственности. Он касается опять трехмерных товарных знаков.
Which one is this? I don't. Не вижу.
Вот Мария Карабанова.
Three-dimensional marks?
Да.
Уже ответил на этот.
Хорошо. Мария, пожалуйста, задайте так, как вы считаете нужным этот вопрос. Так. Хорошо, идем дальше. Вот Анна Говорун из факультета права Президентской академии, она спрашивает по поводу оценки интеллектуальной собственности. Да, пожалуйста, Анна, вы можете от микрофона задать вопрос.
Да, спасибо большое. У меня вопрос, вы, в принципе, правильно сформулировали, да? Как правильно, справедливо рассчитать цену, да, интеллектуальной собственности?
Но, как вы знаете, у нас система прецедентное право, и вопрос не является, как правильно решать проблемы, как наш Верховный суд и другие инстанции решили этот вопрос в прошлом. И в моем докладе имею ссылку на дело Georgia Pacific, в котором суд принял довольно подробную систему методов для оценки ценностей интеллектуальных прав. If I can turn into English, that was for patent law. It's in some cases, for instance, in trademark law, there are rules in the statutes in quite a bit of detail. in trademark law, the victim of infringement has to show the profits of the defendant, and the defendant has to show any of his costs. And there are other detailed rules. Damages can be tripled for intentional violation, and the goods can be destroyed if they're counterfeit. So there, you have to look at the statute. There are a lot of rules, but then there are many, many rules in the decided by the courts and not in the statute for valuation. And then I mentioned in my talk that in one case, someone took the French rules of interpreting contracts to decide how to interpret contract provisions on valuation. But I think the key is looking at the trademark statutes and at that Georgia Pacific case. You can probably just type Georgia Pacific valuation into Google.
Питер, я прошу прощения. Вот сейчас, поскольку был задан вопрос о оценке интеллектуальной собственности, я хочу привести один пример, когда вопрос об оценке интеллектуальной собственности оказался принципиально важным. Это было в 1991 году, когда после провала путча решался вопрос о судьбе информационного агентства ТАСС. Оно, это аббревиатура расшифровывалась как Телеграфное агентство Советского Союза. Я тогда работал заместителем министра печати и информации. И помню, как меня вызвал к себе тогдашний министр печати и информации и сказал: я поручаю тебе подготовить проект указа президента о том, что мы ликвидируем агентство ТАСС и создаем новое агентство. Я его спрашиваю: а как оно будет называться? Он говорит: оно будет называться Российское информационное телеграфное агентство. Я говорю: но тогда аббревиатура будет РИТА. Он говорит: а что тебе не нравится? Я говорю: РИТА – это хорошее название для информационного агентства где-нибудь в Венесуэле или в Мексике. РИТА, Аргентина, танго, самбо и так далее. Он говорит: хорошо, а что ты предлагаешь? Я говорю: я предлагаю назвать иначе. Информационное телеграфное агентство России, сокращенно ИТАР. Красиво, так твердо, ИТАР. Он говорит: ну ладно, иди, пиши указ. Я иду писать указ и пишу, что создать, значит, ликвидировать, не ликвидировать, а преобразовать агентство ТАСС в информационное телеграфное агентство России, сокращенно ИТАР, дефис ТАСС. Приношу к министру. Он смотрит и говорит: как ТАСС? Убери слово ТАСС. Я говорю: нет, ни в коем случае нельзя убирать слово ТАСС, потому что ТАСС – это товарный знак, это торговая марка, это бренд. Он говорит: убирай, убирай, никакого Советского Союза больше нет. Я говорю: Советского Союза больше нет, но бренд ТАСС остается. Иначе мы выбрасываем, просто выбрасываем на помойку, выбрасываем огромную ценность. Он говорит: какая может быть ценность в этом названии? Я ему говорю: а знаешь ли ты, дорогой министр, сколько стоит, какова стоимость бренда водки Смирнов. Он говорит, сколько? Я говорю, несколько миллиардов долларов. Он говорит, ну и что? Я говорю, я думаю, что бренд ТАСС стоит несколько, ну, может быть, не миллиардов, но миллионов точно. Я не готов выбрасывать миллионы долларов на помойку. И это его убедило. И сегодня это агентство все-таки называется информационное агентство ТАСС. Они вернулись к своему названию, хотя эта аббревиатура уже ничего не означает. Это вот как раз к вопросу о ценности, о стоимости объектов интеллектуальной собственности. Питер, вопрос по поводу понятия плагиат в авторском праве.
Плагиат. Но я могу рекомендовать вам сайт юридического факультета Колумбийского университета о судебных решениях по области плагиата музыки. И там отрывки от музыкальных произведений, от произведения истцов и от положительных плагиатов и решения суд, является ли плагиатом или нет. И очень интересно сравнить. И почти невозможно после знакомства с этим сайтом сказать различие между плагиатом и неплагиатом.
Ну, Питер, это ведь известная среди композиторов шутка, когда спрашивают, нет ли в этом музыкальном произведении плагиата, ответ такой, ну, всего 7 нот. Нот всего 7.
Yeah.
Так, следующий вопрос. Можно ли применять при оценке интеллектуальной собственности только подход с точки зрения доходности?
There are some limitations in the statute as to what you can use. Where there are no clear limitations, say with the right of publicity, the lawyer for the plaintiff can argue various things that make the damages very large, and the lawyer for the defendant will argue various things that make the damage very small. I'm going to be teaching later this morning a case in which a football player sued a video game company that had made a video game with reproductions of all the major football players. And there were interesting questions of law as to whether he had a right of publicity, which he did, and it was a class action on behalf of football players. But then the further interesting question, which was not covered in this part of the case, is how do you distinguish the amount of money that really great players should get and how much should ordinary players get out of that decision? We know what the income, how much money the video game company is making from this, but we don't know how much money what the contribution of the individual football players was to it. So I'm thankful because I have to come up with 5 questions for a written exam, and I think some of these wonderful questions from the audience will be very useful to me when I give my examination next week.
Да, это интересная задачка, действительно. Очень интересная. Так, еще один вопрос в чате, да. А следующий вопрос задает Юрий Зубов. Потому что он сказал, что у него еще есть вопросы. Я не считаю возможным лишить его возможности задать эти вопросы. Юрий Сергеевич.
Well,
уже можно задавать?
Нет. Сейчас профессор Мэггс ответит на вопрос по поводу возможности часть произведения признать самостоятельным объектом авторского права.
I recently published a book, and nowadays publishers often offer the same book in electronic form and on paper. And when they offer it in electronic form, they will sell you an individual chapter. Because say if a lawyer has a question, he only wants the chapter on patent law, he doesn't want the chapter on copyright law. And so they can make more money by selling individual chapters. I'm sure they put copyright notices on the individual chapters. I don't know if they register the copyright to the individual chapters because I have to assign the right to the publisher or they won't publish the book. But I know they are selling it as an individual copyrighted work.
Да, ну, я могу дополнить, что у нас даже название произведения тоже охраняется как отдельный объект авторского права.
Но у нас название охраняется как объектом права товарных знаков.
Ну, можно название зарегистрировать и как товарный знак тоже, это безусловно. Но, так, еще один вопрос. Как переходят права на NFT-токены при дарении и купле-продаже? Интересно.
Ну, я не являюсь экспертом по биткоин и блокчейн, но это как права на отдельный биткоин. То же самое система у нового покупателя будет пароль и код, и только у него. И если он забывает, у никого нет права.
Да, понятно. Так, пожалуйста, Юрий Сергеевич, теперь ваш вопрос.
Спасибо большое. У меня был вопрос достаточно провокационный, ну такой из серии популярная интеллектуальная собственность, но касался искусственного интеллекта. Ну, в России очень остро стоит вопрос в текущий момент. У нас есть концепция развития искусственного интеллекта в Российской Федерации, есть налоговые послабления для компаний, которые занимаются разработкой софтверных продуктов, в том числе используем технологии искусственного интеллекта. Есть целый федеральный проект на эту тему. Но как должно реагировать патентное ведомство? Также, наверное, как и во всем мире, этот вопрос тоже обсуждается в ВАЙПО, в АИС, где вопрос правосубъектности очень важным ставится сегодня. Возможно ли регистрировать права для создателей произведений, результатов интеллектуальной деятельности в области техники, ну и, естественно, в области авторского права, для искусственного интеллекта, то есть для искусственного разума, который эти произведения создал. Является ли он правообладателем или нет? Ну, в России позиция достаточно жесткая на текущий момент времени. Есть, конечно, попытки разных компаний каким-то образом решить данную тему, подать заявки, регистрировать программы для ИВМ, но по сути все равно в основе создания данных произведений является все равно человек. Человек их создает, человек создает программу, создает искусственный интеллект, создает датасеты, которые и в дальнейшем являются правообладателями. Именно эти люди. Вот с точки зрения правосубъектности, что вы можете сказать, как в США дела обстоят с этим вопросом? Регистрирует ли USPTO права на искусственный интеллект? Спасибо.
No, it's just, well, it's part of a bigger problem, which is that of clever means of avoiding taxes using the fact that intellectual property can move anywhere in the world very easily, and you can form companies anywhere in the world. United States, as you may know, has been trying to push a minimum tax of 15% on legal entities engaging in business, so that there would not be tax havens the way Apple somehow does its business through Ireland and never pays any taxes on anything. So clearly there is a problem, and I think it requires an international solution in this broader context. Apple, of course, sells hardware and it sells software, and it sells things like iPhones that it's hard to distinguish the hardware from the software. But I think just as already in the 19th century, a great deal of international cooperation was achieved in the area of patents and copyrights and trademarks. You're going to have similar cooperation by tax authorities to set certain minimum levels of taxation on a uniform basis, and to provide real measures to make it unattractive to do things in tax havens. Certainly now I could write a wonderful computer program if I knew how to do it, and put it in some form a company in a tax haven with anonymous owners and give it the program and make a lot of money. Thus, I don't think there's any way to really find this out. With big companies, they can't operate invisibly, but it's more of a question of making sure they don't have somewhere that they can make it appear that their income is coming from.
Юрий Сергеевич.
Спасибо. Спасибо огромное. Thank you so much.
Спасибо. Питер, пока больше нет вопросов в чате, я вам хочу задать вопрос. Вы говорили о том, что компьютерные программы, они сейчас защищаются как литературные произведения авторским правом. Вы сказали, что в этом есть определенная проблема. Я с вами абсолютно согласен. Потому что, на мой взгляд, это была грубая ошибка. Ошибка мирового сообщества, ошибка ВАИС, когда была принята концепция, что компьютерные программы нужно защищать как литературные произведения. Это была, на мой взгляд, это была ошибка. Потому что представьте себе, ну, хотя бы простая вещь. Так, Кто-то еще у нас включил микрофон. Простая вещь. Давайте подумаем. Если компьютерная программа – это литературное произведение, а дальше с помощью этой компьютерной программы создается музыкальное произведение, то получается, что музыкальное произведение есть производное от литературного произведения. Как это может быть? По-моему, никак. По-моему, здесь какая-то логическая ошибка заключена. Когда само произведение, оно не может создать другого произведения. Там должен быть автор, а здесь автора нет. Потому что здесь есть компьютерная программа, которая литературное произведение. На мой взгляд, это такая вот головоломка, которая была придумана в АИС по настоянию немцев. Но я думаю, что немецкий гений в данном случае дал нам плохой совет.
Well, it certainly has created a lot of problems, such as the one I mentioned about repairing automobiles that are now run by computers. But it also, the problems we are seeing are very small compared to those that the development of artificial intelligence will create in the future, of separating and trying to figure out who is the author, so to speak. So one can expect many more problems in the future along this line. And I have, as I mentioned, my car is 32 years old. Every so often I have to put a patch on it or fix something, but it keeps running. But at some point, unfortunately, it won't be able to be kept running. Perhaps there'll be a ban on gasoline engines. The right of the head of the Copyright Office in the United States to make exceptions to the rules concerning encryption of copyrighted works. I think there are about 30 rules now. It's like my car has 30 patches on it. At some point, you can't just keep fixing little things. You've got to think about really changing the item. I think it was Immanuel Kant who talked about changing quantity into quality. And at some point, you've so patched up copyright, you need to rethink it.
Да, безусловно, эти проблемы носят фундаментальный характер. Я абсолютно с вами согласен. Поэтому я так ценю наше с вами сотрудничество. Так, если больше нет вопросов, не вижу ни рук, не вижу ни вопросов в чате. В таком случае, Питер, вы можете спокойно сейчас немножко передохнуть перед вашей следующей лекцией. Передавайте от нас большой привет вашим студентам. Скажите, что мы им завидуем, что они могут ваши лекции слушать часто, а мы все-таки довольно редко. Но я надеюсь, что это не последняя ваша лекция на нашей кафедре. Я рад, что вы столько уже лет являетесь членом нашей кафедры и так активно работаете на нашей кафедре. А сейчас я попрошу всех участников, оставшихся в нашей конференции, своей реакцией показать, как вам понравилось выступление нашего замечательного профессора Питера Мэггса.
Well, thank you very much for the invitation. It's been a great pleasure, and I've learned a lot from these very interesting questions posed by the audience.
Спасибо, Питер. Спасибо всем, уважаемые коллеги. Кто заинтересован, мы приглашаем вас на наше следующее мероприятие, которое будет 21-22 декабря. Это будет не коллоквиум, а это будет международная конференция, посвященная 30-летию российского законодательства о средствах массовой информации. И профессор Мэггс тоже будет участвовать в этой конференции. Мы услышим его выступление снова. Пожалуйста, на сайте кафедры ЮНЕСКО Высшей школы экономики вы можете зарегистрироваться. Пока регистрация еще открыта. До проведения конференции еще 3 недели. Так что время есть. И следите за новостями на нашем сайте кафедры ЮНЕСКО Высшей школы экономики, потому что это первый наш научный коллоквиум, но далеко не последний. Я хочу заметить, что мы планируем нашу работу в этом направлении продолжать и очень рассчитываем на сотрудничество и с факультетом права Высшей школы экономики, и с факультетом коммуникации, медиа и дизайна Высшей школы экономики, и с Роспатентом, и со многими другими организациями, которые работают в нашей общей сфере. Всем спасибо и до новых встреч.
Спасибо, до свидания.